Hi, this is Unit 2 of AS Law. I'm Max White. For this series we'll be discussing non-fatal offenses, and for this topic I will be reviewing mens rea. Once the prosecution have already established the actus reus, they then move on to the mens rea of the offense. One of the intentions the prosecution can establish is direct intention. This is where the defendant fully intends the action as well as the consequence of that act. This was demonstrated in Mohan 1976, where the defendant drove over the policeman, showing that it was his aim, purpose, and desire to do so. Oblique intention, or as it's referred to, indirect intention, is where the defendant intends the act, but not the consequence itself. An example of this would be if you were rushing to get somewhere and inadvertently push someone to get by them. You intended the action, but not the consequence, which could be serious injury or death itself. Wall in 1999 demonstrates this, as the defendant lost his temper while watching over his infant child, and in doing so threw the infant child at a wall, killing it in the process. This is a leading case on oblique intention. There is a two-stage test that states that a jury may find intention if the consequence of a serious injury or death is a virtual certainty, and if the defendant knew of this, then that would be oblique intention. Recklessness, or as it's referred to, Cunningham recklessness, is where the defendant sees the risk yet goes ahead anyway. This legal ruling is illustrated in Cunningham 1957, where the defendant ripped off a gas meter but didn't realize that in doing so he would have caused illness to the people living nearby. Therefore, he wasn't reckless, as he didn't foresee any risk from his actions, as this is a subjective test. So in transfer malice, the defendant may be held liable for their actions, even if it wasn't the original intent. In Latimer 1886, the defendant swung at a man but hit a woman. This was transferred malice because while he intended to hit one person, he managed to hit another. In some cases, offenses cannot be transferred. This is demonstrated in Pemberton 1874, where the defendant intended to hit a victim with a stone, but instead smashed a window. One was an offense against the person, and the other was against property. The coincidence rule refers to most cases having the elements of actus reus and mens rea. However, there are some cases where the actus reus and the mens rea occur at different times. The court has thought of two ways to deal with these. Fagan 1969 is where the defendant drove over a policeman's foot. That was the actus reus. The mens rea was established when the defendant refused to move his vehicle after the policeman gave him a lawful order to move his vehicle. Fagan was still found to be guilty, as the court held that driving over the policeman's foot and staying on there was a single continuing act. So there was a coincidence of AR and MR when the mens rea was later formed. The second approach is a series of events. In the case of Church 1965, the defendant knocked a woman unconscious, then wrongly thinking she was dead, disposed of her body in the river where she drowned. The defendant argued he didn't have the required mens rea when she drowned because he believed she was dead before he disposed of her body. So in summary, the mens rea can be established through direct intention, indirect intention, and recklessness. Mens rea can be transferred from the intended victim to the actual victim. Mens rea cannot be transferred from different offenses, such as an offense against a person and an offense against property. And that there is a coincidence rule for such cases where the actus reus and the mens rea do not occur at the same time. So in the next video, I'll be reviewing strict liability. See ya.